I'm gonna start this reading. Indian Contract Act 1872, Act number 9, 1872. I'm gonna let it scroll so y'all could check it out, cause I'm not gonna read all that, you know. This is gonna be in different parts. What they call like series. We like to call them the new series. NU series. New series. It's something we bringing forth that's not new, but it's new to a lot of people. Because we wasn't reading. It's new to me too. I didn't this is what you'll be going through if you was in business, if you went to business law in school. Poof. And if we would have knew that, boy. Poof. Business law. Mm-mm-mm-mm. General lien of bankers. Pledge, partner, and pawnee. Agent and principal. Who may be an agent? Sub-agent. It is November 23rd or 24th on the Gregorian calendar year. Thursday, I think. Liability of pretended agent. Oof. There's a lot in this act. Preamble 9 of 1872, whereas it is expedient to define and amend certain parts of the law relating to contract, it is hereby enacted as follows. 1. Short title. This act may be called the Indian Contract Act. It say this act may be called that's wrong. This act may be called the Indian Contract Act 1872. Extent, commencement, it extends to the whole of except the state of Jammu and Kashmir, and it shall come into force on the first day of September 1872. Gotta think this is India, but it applies. Enacted, repealed, nothing herein contained shall affect the provisions of any statute, act, or regulations not hereby expressly repealed, nor any usage or customs of trade, nor any incident of any contract not inconsistent with the provisions of this act to interpretation clause. In this act, the following words and expressions are used in the following senses unless contrary intention appears from the context. A. when a person signifies to another his willingness to do or to abstain from doing anything with all view to obtain the absent of that other to such act or absentence, he is said to be a proposal. He is said to make a proposal. B, when a person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. When accepted, becomes a promise. Okay. C, the person making the proposal is called the promisor, and the person accepting the proposal is called the promisee. When at the desire of the promisor, the promisee, or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. So, it's a consideration for the promise. E, every promise and every set of promises forming the consideration for each other is an agreement. F, promises which form the consideration or part of the consideration for each other are called reciprocal promises. Promises which form the consideration or part of the consideration for each other is called the reciprocal promise. G, an agreement not enforceable by law is said to be void. H, an agreement enforceable by law is a contract. An agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. J, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. It says chapter 1 of the communication, acceptance, and revocation of proposals. 3. Communication, acceptance, and revocation of proposals. The communication of proposals and acceptance of proposal and the revocation of proposals and acceptance, respectively, are deemed to be made by any act or omission of the party proposing, accepting, or revoking, by which he intends to communicate such proposal, acceptance, or revocation, or which has the effect of communicating it. 4. Communication when complete. The communication of a proposal is complete when it becomes to the knowledge of the person to whom it is made. The communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. As again the acceptor when it comes to the knowledge of the proposer. The communication of the revocation is complete as against the person who makes it when it is put into a course of transmission to the person to whom it is made so as to be out of the power of the person who makes it, as against the person to whom it is made when it comes to his knowledge. 5. Revocation of proposals and acceptance. A proposal may be revoked at any time before the communication of the acceptance is complete, as against the proposer, but not afterwards. An acceptance may be revoked at any time before the communication of the acceptance is complete, as against the acceptor, but no afterwards, but not afterwards. 6. Revocation. How made? A proposal is revoked, 1. By the communication of notice of revocation by the proposer to the other party, a notice of revocation. 2. By the lapse of the time prescribed in such proposal for its acceptance, or if no time is so prescribed, by the lapse of a reasonable time without communication of the acceptance. 3. By the failure of the acceptor to fulfill a condition proceeding to acceptance, or 4. By the death or insanity of the proposer, if the fact of the death or insanity comes to the knowledge of the acceptor before acceptance. 7. Acceptance must be absolute. In order to convert a proposal into a promise, and acceptance must, 1. Be absolute and unqualified. 2. Be expressed in some unusual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted, and the acceptance is not made in such manner, the proposer may, within a reasonable time after acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. 8. Acceptance by performing conditions and receiving consideration. Performance of the conditions of proposal for the acceptance of any consideration for a reciprocal promise which may be offered with the proposal. It is an acceptance of the proposal. Acceptance of the proposal. Promise, express and implied. Insofar as the proposal or acceptance of any promise is made in words, the promise is said to be express. Insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. Chapter 2 of contracts. Viable contracts and voidable agreements when we get back. We're going to do it